Tonight, the Utah Supreme Court is hearing arguments on if the controversial Amendment D should be voted on this November.
Now, this is the proposal to revise protections for laws passed by the voters. Jonathan May is following all of this for us, breaking down a hearing that lasted over 3 hours. Jonathan, where do we start here?
Well, Sarah, Brian, today's back and forth started with the justices hearing arguments from the legislator's attorney. She argued against the injunction, saying it should be up to the voters. Now, if the measure passed, lawmakers could change or reject citizen initiatives after they pass.
We're here on the case of League of Women Voters versus the Utah State Legislature.
Plaintiffs could have opposed Amendment D at the ballot box, but instead they went to court. They obtained a statewide mandatory injunction ordering that no Utahns' votes be counted.
What Constitutional Amendment D would do is extinguish the constitutional protection that the same government that the voters sought to reform could not veto the reform passed by the voters.
We're here after Utah's 3rd District Court seemingly sided with groups challenging the measure, like the League of Women Voters.
I think the voters would be absolutely confused. I think of myself as an average voter. I'm no more educated or uneducated than anybody who picks up the ballot, who gets it in the mail. And it is extremely confusing language. It is deceptive language.
A judge ruled to grant an injunction over the proposed amendment 2 weeks ago. State Republicans challenged it. The big talker of the day, would voters know what they'll be voting for or against?
I think probably the most revealing disconnect that we had with the district court is this idea that a voter looks at their ballot alone and they only know what the amendment is about based on that ballot summary.
As a voter, shouldn't you be able to trust that the ballot itself is playing it straight?
There is nothing in the ballot language that informs the voter that that is the fact. It is false and misleading.
If the measure passed, critics worried legislative power would be taken away from the people.
I can't really speak to what the court will do. I think they will do what's right for the voter, and what's right for the voters is to keep this off the ballot or void it.
Even if the court disagrees with all these arguments, the injunction is still overbroad. Plaintiffs' particular claims can all be redressed with more notice, short of canceling the vote on Amendment D.
The justices will now take the case and consider all the arguments. It's up to them now. No word yet on the timetable on when they'll give their opinion, but we'll of course keep you updated both on air and online at abc4.com. Sarah, Brian, back over to you.
Okay, Jonathan, thank you very much. We'll continue to keep an eye on that one.